Counsel.
Please report, Counsel. My name is Jeff Bethune, and I'm here on behalf of the appellant in the case, Fernando and Candida Subirats.
Mr. Ligman?
I'm Mr. Bethune for Mr. Ligman's office.
I'm sorry, you're who?
Mr. Bethune. It's sort of a tough Belgian name. I apologize.
All right, well, I was hoping that Mr. Ligman might be here. We issued an order in July. Are you familiar, Counsel, with the requirements for filing a non-final appeal in this court?
I've tried to follow them as properly as possible.
Are you familiar with the need for an appendix, because we do not get a record from the court below in a non-final case?
I'm familiar. I apologize.
You know that.
Yes,
case. Okay. Do you know that with respect to that the index is supposed to be not only separately filed, but is to be indexed and paginated?
I was not aware until recently.
Not aware until how recently?
Probably what was in the court's order. It was a little bit in
the court's order. Well, the court's order was, you saw the court's order, I guess, in July 20th.
I didn't see in July 20th, I just see the court's order
sometime thereafter. And did you all file an appendix to comply with the court's order?
We were unable to in time, Your Honor.
And you had July 26th until today, about six weeks.
We thought this case had come to a settlement, and there was some secretarial confusion, Your Honor.
And did you receive the telephone call, or did Mr. Ligman?
I actually received the telephone call. I talked to Debbie here at the office, Your Honor.
And you told her that you would do it, right?
I told her I was going to try to find out what was going on with the actual appendices and try to get it filed. And the first time I actually got a call.
You never filed any motion to extend or for additional time or anything like that?
No, Your Honor. I thought my appendices had gotten over, and I apologize. I did not know.
Do court orders mean anything?
Yes, Your Honor. Very much so.
You know what happens, what can happen if somebody doesn't follow a court order and other courts?
Most certainly, Your Honor. And I apologize. It was a secretarial mistake, and I apologize.
You're trying to blame it on your I'm counsel.
No, Your Honor.
You're the one who took the bar exam, right?
I am, Your Honor. I will take full responsibility.
You were a secretary that didn't get something done.
No, I will take full responsibility. It was my fault. I did not file it.
How long have you been a member of the bar?
Less than 2 years, Your Honor.
Less than 2 years.
Yes.
Okay. Counsel, you may not be off to a very good start.
Although, Your Honor, I would hope not to incur the wrath of the court.
Is this your first argument here?
Yes, it is, Your Honor.
Okay. Hopefully, in your next one, you will have followed every order.
And I apologize to the court, Your Honor.
And why aren't the merits of this case controlled by our court's decision in Colosimo?
Well, we did cite Colosimo. I do believe that.
No, I know that you did. I'm not convinced that it's distinguishable because of the footnote that, in effect, anticipates some of the arguments that you're making, at least.
Your Honor, I do believe that it's controlled by the statute and the rule that's implemented, for the administrative rule that's implemented by the statute.
Okay, so your argument would be if the mediation notice is given late, that's it. It doesn't matter if there was a later notice that conforms in every respect except the time. Is that
correct? Okay. It was not given properly for the time period it was supposed to be for the statute and for the rule implementing that statute.
Right, and then you're also saying that if the parties disregard the mediation notice issue and proceed down the road to designate appraisers, and those appraisers get into the process and come up with some values or begin to disagree about who the neutral ought to be, you're saying that even with that conduct, it doesn't matter?
We would hear the insured's could be very confused by the appraisal process, just as Inclusive sort of alluded to, that this is a process where they're confused with the process here. They had a representative, they were very confused after being frustrated with the appraisal process. What they saw was a lack of process in the appraisal area. They decided to move towards litigation.
That's because, similar to what we were talking about just a moment ago with you, the appraiser didn't respond to any inquiries, right? About the same, seems to me that maybe on your side of the fence, responding is not a policy or responding is a policy that's often honored in the breach. Would that be accurate?
I would say that, from what I understand in this case, there is accurate that there was some type of lack of communication.
That your appraiser did not respond, sort of like you not responding to the order for some reason.
Yes, Ron.
Might have been excusable in that particular case, but didn't respond. But there was this appraisal was demand by your clients was made after the notice did in fact go out, albeit late.
That is correct, Ron.
And that fact distinguishes this case factually from Colosimo, correct?
I will agree. Yes, I figure there is a distinction because the notice was given here, albeit late. There was a notice, and when I've seen it does conform with the.
So the holding of Colosimo doesn't apply directly to this case, correct?
No. We went more.
You agree with me that it doesn't. I don't want the yeses and nos to be messed up here.
Yes, Ron, I agree with you wholeheartedly.
That may provide some guidance. It may not.
I agree. We went from the guidance given in the footnote in Colosimo, which talks about, I believe it's QBE versus Doom, where it says...
Which says even if it says something in effect, well, even if we had this issue before us, we would say still
for the 5-day requirement.
The insured wins, right? That's in substance what
that is correct.
What it says. That's classic dicta, correct?
Yes, Ron.
And with respect to the 5-day rule itself, Counsel, the question of whether or not, you may not know this, the question whether or not it was whether or not the rule comports with the statutory authorization was not raised in Colosimo, was it?
No, it was not.
But it is raised here.
That is correct, Ron.
And why is it not? Why under the State Farm versus Unlimited Restoration case, under that particular case, why does not the reasoning of that case apply here? Namely that in that particular case, there was an additional requirement placed on in this exact rule, this exact set of rules, and another court of appeal reasoned that condition was unenforceable because it was an additional condition placed on the insurance company in excess of the delegation.
And I believe under 627-7015, Part 4A, it does say that the Administrative Code contains a reasonable requirement for processing and scheduling of requests for mediation. I would believe that the 5-day bright line rule that's cited in the Appellate's brief.
You're reading from the rule.
From the actual statute itself, Your Honor. 627-7015.
Statute says that it shall be, the statute says that it shall be given, right?
It should be on the Part 4.
All it says is notice shall be given. It doesn't say 5 days.
No, it does not, Your Honor. I'm talking about subsection 4, where it lays out that the Department of Insurance shall adopt by rule a property insurance mediation program, including.
Yes, that's what it says. And applying that, looking at that delegation in the statute in the unlimited, have you read the unlimited restoration case?
I have not read it before.
You have not read that. Pardon?
No, Your Honor, I have not.
You've not read that. It is cited in the briefs. And so maybe for your next argument, you might also have read the briefs and the cases. So I can ask you some questions.
Yes, sir. I apologize.
Thank you, counsel. We'll hear from the appellate now.
May it please the court.
Counsel, that 5-day rule is well within establishing a program, is it not?
Your Honor, no, the 5-day rule that you're referring to is not a rule that was legislatively authorized by the Department of Financial Services. As you pointed out in 627-7015 subsection 4, that is the section that the statute delineated the powers and specific powers and duties that the agency could adopt. And pursuant to...
And what does it say?
It states, the Department shall adopt by rule a property insurance mediation program to be administered by the Department or its designee.
So why is not a requirement that the insurance company shall give the notice within 5 days within the program?
Because, Your Honor, pursuant to the Florida Administrative Procedure Act in Chapter 120, it specifically says that an agency may adopt rules only that implement specific duties or powers.
Again, I didn't hear you. You need to speak up a little louder for me, counsel.
I apologize, Your Honor. Because pursuant to Chapter 120 of the Florida Administrative Procedure Act, the agency may adopt only rules that implement specific duties or powers granted by that enabling statute, which is subsection 4 in 627-7015. There is nothing within that statute that grants the power to the Department of Financial Services to implement a bright-line rule on the time frame for notice.
So you're saying subsection 4 says the rule shall provide for, and then it lists 1, 2, 3, 4, 5, 6 things, and none of them relate to time limitations. It talks about processing, scheduling, qualifications of mediators, who can attend a mediation, selection of a mediator, conduct of the mediation, and right to counsel. None of those talk about imposing additional obligations with regard to notification of the right to mediate.
Correct, Chief Justice. And while
I'm not a justice, I'm just a judge. That's the Supreme Court that a justice.
I apologize, Your Honor. Plaintiff wants to say that the scheduling and request for mediation in that subsection encompasses time to notify, and that is a misreading of the statute in subsection 627-7015-4A. Nowhere in there is there any kind of limitation or the power to grant a limitation on that time frame to the department. And also, I would like to point out that there's been other cases, the Southwest Florida Water Management District case, and the Lamar Outdoor Advertising case. Specifically in Lamar, the court pointed out that any sort of general powers granted through the enabling statute cannot be applied when there are specific powers granted. And within subsection 4A of the statute, there are the specific powers, as Judge Wells just recently enumerated them, that those are the powers that are granted and nothing within that grant time frame.
Well, what do you have to say about the rule itself when it talks about, the rule does have a provision that talks about notification of the right to mediate, and that's the part that imposes the 5-day obligation. The way I read that, it looks like it provides a sanction in that subsection for failure to do so. And what is that sanction?
Correct, Your Honor. It's an administrative remedy that is called for there. Nowhere in that rule, in 69J 166.031, is there any indication of a waiver provision. The only waiver provisions exist within the statute, and those are a failure to notify or if the insurer invokes and the process is unsuccessful. Neither one of those circumstances exists here. And pursuant to the State Farm case, as Judge Shepard recognized, in the State Farm versus Unlimited Restoration case, the court specifically held that the rule cannot create an additional instance of waiver that does not exist within the statute. That's the precise situation we're in here. The plaintiffs want to argue that the rule at issue here adds an additional waiver provision that's not within the statute. And based on State Farm, that's not the case.
So the remedy of the insurer's to the extent that they have one for a late notice, is to complain to the Office of Insurance Regulation.
Well, correct, Your Honor. And also I would like to point out the distinguishing factors of Colosimo, as Judge Shepard pointed out. And again, there was a violation of the statute. There was never notification in there. The reference in footnote 1 to the rule also... That case says very plainly that if it is not given in 5 days, notice is not given in 5 days, then appraisal is not required, period. If we affirm this case, are we not in conflict with the actual holding, not the footnote, but the actual holding of Colosimo? No, Your Honor, because in Colosimo, as Judge Wells knows, she was on the panel, the holding in that case was based on a violation of 627-7015. The footnote and dicta regarding the 5-day rule was not used to support the holding, nor was the validity of that rule addressed or examined in that case. The 5-day rule issue was not preserved for appeal in that case, and it related to a prior claim and not the claim that was at issue. Therefore, if you uphold the ruling below here, it will not be in direct conflict with Colosimo because it's factually dissimilar, and the rule was not evaluated in that case. All of the case law cited by plaintiffs in support of their argument, there was a failure to notify, a complete failure, which is one of the instances of a waiver of the right to appraisal under the statute. It's one of the two specific ones. Therefore, the defendant, Fidelity, argues that we did not violate the statute and we did not waive our right to appraisal, and we ask that you uphold the ruling.
Counsel, I'll give you another minute. You have a minute for rebuttal. If there's anything else you wish to tell us?
Just briefly, we would disagree. We believe that there was a violation of the duty to notify, and we feel that burden as per Colosimo is on the insured to notify their insurer properly.
Thank you, Counsel.